Public Enterprises Minister Pravin Gordhan has gone to the courts to challenge the Public Protector's report, which found he violated the Constitution. Gordhan lodged an urgent application in the North Gauteng High Court yesterday. He wants the court to suspend and interdict the remedial action from being enforced against him until a judicial review of the report has been completed. On Friday, Public Protector Advocate Mkhwebane made damning findings against Gordhan when she released her report in the so-called SARS rogue unit. She found Gordhan had misled Parliament and had violated the executive member's code of ethics. She gave President Cyril Ramaphosa 30 days to take action against the minister. In the court's papers, Gordhan questions Mkhwebane's competence and integrity. He says that rather than dealing with the citizens' complaints, Mkhwebane is using her office for political motives. Now, for more on this story, we're joined on the line by Minister Pravin Gordhan's lawyer, Tebogo Malatji. Mr. Malatji, a very good morning to you and thank you for joining us. In a statement you released with regards to this court request, you're saying that, scathing on the Public Protector, saying she misapplies provisions of the Constitution and applicable legislation when making adverse findings. But also I just want to read one part where the minister says that in the overall interest of justice, because I strongly doubt the bona fides of the Public Protector in investigating and issuing the report, the Public Protector has confirmed that I am the subject of 3 ongoing investigations by her office. I'm not aware of anyone who has been singled out and pursued by her office in this way. Are we disregarding the facts and making this a personal battle?
Morning to you and viewers. I think the point we're trying to make is that Minister Gordhan's cases, complaints against him are firstly quite hastily attended to, and secondly, there's even more that we learn about in her pronunciations, which we haven't been informed about, and it is unusual and undue attention to one particular public official, and that's the point we make, and we say it's one of many grounds that support our belief that there is bias. Alternatively, there is ulterior motive.
In giving advice to your client, what's to be said about the binding nature of her decisions?
Well, what we say is that, like all functionaries, and I mean, she's elevated to some extent her findings to the equivalent of a court order, if you have regard to what was said on Friday by her. But all functionaries that perform public functions, and that includes all constitutional institutions, they are exercising, after all, a public power, which is subject to court judicial review, oversight. So our concern still remains that once a process is commenced to review her action, at least deference should be given to the courts to determine whether that particular remedial action as recommended will sustain judicial scrutiny or not.
You also find her wanting in how she gets to her decisions. For instance, one of the things you mentioned, which is one of the cases she looks at, is there is no legal obstacle to SARS establishing an investigative unit to deal with tax implications for organized crime and illicit trade. Why do you think she feels that this was against the law?
Well, she's advocated 2 arguments. The one is that the unit was established in contravention of Section 209, and I'll get back to that. And then the other one is what we call a misreading of the National Strategic Intelligence Act. Now, the easier one to understand is that Section 209 says only the President can establish an intelligence service. The investigative unit that was established under the tax laws was not an intelligence service, and therefore doesn't fall under Section 209 of the Constitution, and therefore there could not have been a contravention of Section 209 of the Constitution. A more delicate and very complex interpretation of the National Strategic Intelligence Act says that which we established, well, when I say we, I mean we first established as an investigative unit, does not do what the National Strategic Intelligence Act says can only be done by certain organs of the state, because it remains exactly that. It investigates tax matters, illicit trade, organized crimes, people who have very complicated ways of avoiding to pay tax. That's what it is. It's nothing. It's nothing to do with the intelligence service, because the intelligence service is with a view to protecting the security of the state, and that was not the intention of the unit. And certainly, when it was established, and its activities will be borne out not to reflect that.
Minister Gordhan says that rather than dealing with citizens' complaints, Mkhwebane is using her office for political motives. What do you say to the narrative that also says, you know, this matter has dragged on for far too long now, why doesn't Gordhan just walk away?
Well, do you walk away in circumstances where there has been exoneration of wrongdoing by many bodies? And I mean, let's start with the Sunday Times. It retracted and apologized for the report, which was the genesis of all of this. Let's go to KPMG, which it conducted an investigation, was paid 23 million and refunded the 23 million because it retracted the report and distanced itself from the report. Let's go to Judge Kruon, who was appointed to an advisory board, who has since testified before the Nugent Commission and said, I was wrong, and has in fact issued an apology to the affected officials. Let's go to the Nugent Commission of Inquiry itself. Now, all of those surely must indicate, and then we go to, of course, the Hawks themselves in 2015-2016 investigating, culminating in the NDPP saying no wrongdoing. So those are 5 different instances of looking at the same facts that she has looked at and looking at the same law that she has looked at and that has said there's no wrongdoing. So, I mean, how do you walk away in circumstances where you're now being declared to have contravened the Constitution and to have contravened legislation in circumstances where it's clearly not, let alone our own submissions, which clearly indicate that she's gotten it wrong.
So the Public Protector yesterday told the Justice Committee in Parliament that her office continues to face harsh criticism from officials who've been implicated in her investigations. Are you harassing the Public Protector?
Well, no. All you have to do is to look at the court cases. Just look at the litany of court cases. Now, we're not even talking about those that are pending, because when you look at that report of hers to Parliament, there's actually 30 review court applications, if my memory serves me well, that are taking her reports on review. Now, some are meritorious and others not, and we don't need to get to that debate. But when you get to that number, in terms of people that say, well, you haven't done you haven't discharged your duty, and you got it wrong, fact or law, it's quite concerning. But look at the findings of the court. So you've got the ABSA case, you've got the Reserve Bank case, you've got the Freire Dairy case, you've got the Minister
but
and
Mr.
Queen's
Malatji,
case.
you can't
and all of those. No. Let me just finish this point. Now, all of those cases have 2 elements to them, all of them. And the one element is you haven't done your job, as in you haven't investigated the facts. Secondly, all of those cases about you got the law wrong. So with all of that, and we're adding now the 2 review applications that we have, and we see a similar pattern, then it must be a matter of concern.
Now, what do you say to the assertions of the Public Protector spokesperson who is insistent, and this is the concerning part, I think, for the public, that you saying she gets the law wrong, and he wrote an article the other day saying everybody who is a detractor against these reports gets the law wrong. What are we to make of all of this?
Well, I mean, in the end, I say the exercise of public power, which is what she's been granted by the Constitution and the Public Protector Act, is subject to judicial scrutiny. So nobody is above the law, and not the public protector as well. So when you exercise that public power, you must be subject to public scrutiny. And only the history and the profound findings of the court must speak to the office and the incumbent of the office. And we can't say no more or no less than that. You know, any other theory is at any rate a theory and not a matter of fact law, because there's no findings. And we fight all of these cases as a demonstration that there is a challenge in the office.
So now the application that you've launched is seeking to suspend and interdict the enforcement of remedial orders. The public protector wants these remedial action that the public protector wants to be implemented. She has ordered the president to work on these in the next 30 days. What kind of responses are you hoping to get from the courts?
Well, what we're saying is if a functionary exercises public power and performs a public duty and gets it wrong, then there's judicial oversight over that particular exercise. In this case is the issuance of the report and the remedial action recommended therein. Now, all we can do is to go to court and say, review and set aside the report because it is factually and legally incorrect. But what we do know, our constitutional court has said, well, you just can't simply ignore what she's said must be done. And that is a direction to the president, to the speaker, to the National Director of Public Prosecutions, Minister of State Securities, and so forth. We can't, in this particular instance, we can't because there are deadlines. So in the court application, we've got two parts. The first part says stay the implementation because a court must exercise judicial oversight and decide whether she's correct or not in her findings, the remedial action in a review application. So Part A says stay the implementation of the remedial action. The president need not act until a court has determined whether the report is sustainable or not.
So where to from here?
Well, from here is on the 23rd of July, we'll be in court for what we call Part A, which is the stay and interdict the implementation of the remedial action, or rather the insistence by her that remedial action must be implemented. You remember that's what she said at the media briefing, that people must bring an application to stay, otherwise it's effective. And then second would be the more substantive application, which seeks to review and set aside a report on the grounds that it's unconstitutional, it's irrational, it's unlawful, and so forth.
Thanks for talking to us this morning. And just finally, is your client feeling that he's on the right side of the law on this matter? Or these matters,
Absolutely.
if you like?
Absolutely. As I've demonstrated to you, not even the prosecuting authority could find anything wrong about the establishment of this unit. Not the New Gen Commission, and certainly, from our perspective, we've advised him that his conduct in relation to the matter is above board. But it's not only us; it's all of those instances of review of the conduct pertaining to the establishment of the unit that give credence to his belief that he's acted in a manner absolutely above reproach.
Right, there's a lot that we could talk about in relation to this matter, but obviously, as always, we have time constraints. Mr. Malatji, thank you so much for making the time this morning. That's Minister Pravin Gordhan's lawyer, Tebogo Malatji.